Imagine you have given a tenant proper notice to vacate your property, but the notice period has now passed and they are still there. It is a tough spot for any property owner, filled with questions and potential stress about what you should do next to protect your investment. Once a notice to quit has expired, the very next essential step for a landlord is to initiate a formal eviction lawsuit through the court system. This process is typically known as filing an unlawful detainer action, and it is the legal path to regain possession of your property. The reason this legal route is mandatory is straightforward. As a property owner, you cannot simply remove a tenant or their belongings yourself, even if they are legally supposed to have moved out. Such actions, known as self-help evictions, are strictly prohibited by law and can lead to significant legal penalties against you, including hefty fines and even being forced to allow the tenant to return. The court process ensures that all parties receive due process, safeguarding everyone's rights while providing a structured and lawful method for resolving the situation. Remember, every state and local jurisdiction has specific laws governing these procedures, so understanding the requirements where your property is located is crucial. So, what does this legal process look like in practice? First, take a moment to carefully review the original notice to quit you provided. Ensure it was served correctly according to your local laws and that the entire notice period, such as 30 days or 60 days, has fully expired. Next, gather all relevant documentation. This includes your lease agreement, any notices you served the tenant, comprehensive records of rent payments or non-payments, and any correspondence you have had with the tenant. These documents will be critical evidence in court. It is highly advisable at this stage to consult with an attorney specializing in landlord-tenant law. They can guide you through the specific forms and filing requirements for your jurisdiction, helping to prevent costly mistakes. The attorney or you will then prepare and file an unlawful detainer complaint with the appropriate court. This formal document states why you are seeking to evict the tenant and what relief you are requesting. After filing, the tenant must be officially served with a summons and a copy of the complaint. This is usually done by a professional process server, sheriff, or marshal to ensure it is legally valid. The tenant then has a specific time frame, often 5 to 7 days, to respond to the court. If the tenant responds, a court hearing will be scheduled. You or your attorney will need to attend and present your case using the documentation you gathered. Should the court rule in your favor, they will issue an order for possession, sometimes called a writ of possession or writ of restitution. This is the official court order that gives you the right to regain your property. Finally, and this is another crucial point, you will typically need to coordinate with local law enforcement, usually the sheriff or marshal, to physically remove the tenant and their belongings if they still refuse to leave. Under no circumstances should you attempt to do this yourself. A valuable tip for landlords is to be aware of any local rent relief or eviction diversion programs. Some jurisdictions requiring landlords to explore these options before or during the unlawful detainer process, and they can sometimes offer a path to resolution without a full court hearing. Additionally, understanding the concept of a stay of execution is important. This is a temporary pause in the eviction process that a judge might grant under specific circumstances, often if the tenant can quickly pay back rent or meet other conditions. By meticulously following these precise legal steps, you not only protect yourself from potential legal repercussions, but also streamline the entire process of regaining possession of your property. Adhering to the law ensures a fair and peaceful resolution for everyone involved, allowing you to move forward confidently and responsibly as a property owner.